Who on to this event. For those of you who don't know me, Rick Bigwood is my name. I'm the head of school of the law school just over in that. Really here to kick off proceedings. Of course, we're very lucky to have the Honourable Justice Peter Applegarth AM with us tonight. Tamara will introduce him. I just want to start by acknowledging the traditional owners of the unceded land on which we're gathered here this evening. So the people of Turrbal and the Yagara nations of Meanjin, and personally and on behalf of UQ, I'd like to pay my respects to the elders past, present and emerging who continue in their traditional activities on these lands. And I'd like to extend my respect as well to other Aboriginal and Torres Strait people if they're present this evening. So as I say, we're very lucky to have His Honour here. Tamara will come and introduce him. I was thrilled to be here because it's the only invitation I've received that says no dress code, because usually they put a dress code in if they know I'm coming, but I did get dressed nonetheless. Thanks for that. I don't know if that was Caitlin or Chloe's innovation, but thanks as well to Chloe and Caitlin, Tamara for her efforts as well. Faye, you probably had something to do with it as well, so thank you for that. Look, without further ado, just allow me to introduce Professor Tamara Walsh, the Director of the Pro Bono Centre, to introduce our guest. So thanks, great to see such a good attendance.
Hi everyone, I'm Tamara Walsh. I am the Director of the Pro Bono Centre, and on behalf of the Centre I'd like to also acknowledge the traditional owners of the lands on which we meet tonight and pay our respects to their elders past, present and emerging, and recognise their amazing contribution to the legal profession in Queensland and the broader social service sector. We are so lucky to have Justice Applegarth here with us tonight. Justice Applegarth was appointed as a judge to the Supreme Court in 2008, and before that he had a long and distinguished career as a barrister here in Brisbane. He's also a graduate of our law school. So I, for many years, have been giving my students in all of my classes Justice Applegarth's paper on issue framing. And I think it's one of the most important papers that students can read, and those of you who I've taught will have heard me say that. So I'm so happy to invite Justice Applegarth to the lectern tonight to speak to that paper. Please make him welcome.
Well, thank you, Dean. Thank you, Professor Walsh. I join in the acknowledgements. I'm delighted to be here at Pro Bono Centre, as I have been for many years. When I was a law student, there wasn't such a centre, but law students still did pro bono work. In fact, my first case was as a pro bono law student, third-year law student. It was during the height of the Right to March era, when peaceful assemblies were banned by an edict, and as a result, hundreds of people protested and got arrested. The high-profile arrestees, senators, trade union leaders, they got pro bono barristers or very skilled pro bono solicitors like Wayne Goss to act for them. The long-haired, unwashed got law students to act for them, and I was one of them who was acting for a guy who I met about 2 minutes before the case. He was charged with disobeying a lawful police direction, which was the usual charge. He'd been sitting, I think, on the stairs of King George Square, and the police sergeant who gave the evidence against him said that he came up to this guy and gave him a direction to move, and the guy didn't move. I didn't do a lot of preparation, but I just came and should ask the police. So there's a lot of noise going on, yes. And after he gave the direction, he didn't move at all. Yeah, he didn't move at all. And I said, well, how can you be so sure that he heard your direction? And he hesitated just for a second. You know, he said, well, I think he probably did. I called my client, I think he would have said that he deliberately disobeyed the directions. I didn't call him. I just said to the magistrate, well, in light of the evidence where he didn't move and there's evidence that he mightn't have heard it, how can you be satisfied beyond reasonable doubt? Direction. Now, amazement, to my client's even greater amazement, the magistrate said that he wasn't satisfied beyond reasonable doubt that my client had heard the direction. And without knowing it, I'd framed the issue for the decision. Well, after that terrific success, I went on to lose a lot of cases, both as a law student and as a barrister. In retrospect, I should have just quit after that case, and I could have traded on the reputation of having never lost a trial. Coming to the present, we live in an era in which judicial decision makers, and I'll just maybe call them judges, and that embraces judges, magistrates, tribunal members. We live in an era when compared with artificial intelligence, and this reinforces the idea that we're decision-making machines, may be better, maybe worse than artificial intelligence, that it involves the mechanical application of rules to evidence. And that's an interesting conception. When I was a law student or a judge associate article clerk, I'd see judges and lawyers, Connolly and Bill Pincus, and I just think they're amazing decision-making machines. I used to call Bill Pincus the judge with two brains. I mean, these people just had this amazing capacity, which I admired. However, even the smartest lawyers, like a Kiefel or a Keane or an Edelman, on their processing powers, and at all, I'm going to and at all levels of the judicial pyramid, we're short on time and overloaded by information. My friend, Professor Kylie Burns at Griffith University commenced an article about judges' common sense and judicial cognition with these words: judges are like other human beings. And I had a joke at Kylie's expense, functionally saying, Kylie, did you really need to put a footnote to have citations for the fact that we're human beings? But her citations included Jerome Frank's 1931 article, an article by Professor Guthrie, and a 2014 article by Justice Gagler. And in that article about cognitive biases, she deals with the problem that psychologists refer to as bounded rationality, which affects us all. It affects High Court judges would have huge appeal records that even with the assistant, like Ms. Connolly here, they have to enormous amount of information. We might think the High Court only decides 50 important cases a year, the ones that make it into the CLRs, but they have enormous volume of special leave applications. I can't begin to tell you how busy magistrates are, mental health tribunals, so huge overload, and there's just so much that people can absorb. It brings me to the topic of issue framing. There's a natural tendency, and I'm sure I was guilty of it when I was at the bar, not just at the junior bar. There's a natural tendency on advocates to try to demonstrate to the judge that they have done an enormous amount of preparation. They want to tell me at the start everything about the case and all about the law. Now, please, I admire that, but could you just tell me that later? There's no point if I'm doing applications tomorrow like I did today to just come in and just go blah, 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 blah. I'm just not going to get it. I'm really just not going to get it. And so I don't want to hear all that at the start. I might want to hear a fair bit of it in the middle, but I don't want to hear it at the start. This leads me to what issue framing is. And the point is that in the first few minutes or in the first paragraph, I just want to know who did what to whom, who's claiming what, who's been charged with what the rule is, and what the issue is. And as you see there, whole body of work has to pose the question, the answer, the reasons for the answer. And an ideal introduction states that concisely. And these great judges, Frankfurter was, of course, a Harvard professor before he became a great judge, Carl Llewellyn, in different ways said, if the judge accepts the way you frame the issue, you probably win the case. You mightn't necessarily win the case, but you're well on the way to winning the case. And of course, there's more than one way to frame an issue. Doyen of legal writing is a law professor in America called Professor Brian Garner, and there are some of his tips. Short, sharp sentences, enough facts to give it a bit of context, who did what to whom. Brief statement of the rule, don't need a whole bunch of citations. And you frame a question at the end. Typically the format's statement, might be statement of fact, statement of law, question. That's it. I read the classic comic version of Tale of Two Cities. I didn't feel the need to ever go back and read the novel, but most people who've read the novel remember the opening words. They don't remember the end. And that's why the opening paragraph of the written submissions, the opening couple of minutes of an oral submission is what you might say if you're in the property business, very valuable real estate. And most barristers, whether they're doing with an appeal or start of a trial, they'll start up and start droning on, well, you know, after the appearance, you're on a turn to page so-and-so, and you'll see clause whatever. And why would you bore me? Because like I've got such a short attention span, the last thing you want to do is bore me. I probably read about clause 17.4 if I've done any preparation. If I haven't done any preparation, like I won't have tomorrow when I've got a whole bunch of cases that just keep on coming through the door, I haven't got the time to read them. You know, one of my other judges will be doing 6 bail applications back to back. We don't read all these things in advance. If we haven't read it in advance, the best thing to do is not to bore me with what clause 17.4 says and take me to its full text. It's to tell me what the case is about. And that's just a simple, short thing. It doesn't say the date of the contract, doesn't say too much, simply states what the issues are. And there you go. Now, you're going to have to expand on that. You might later set out, you really had to. Then you might preview the defence, because it's all well and good saying what your case is, but you've got to say why the other case is defective or deficient. We wouldn't use a term like rubbish, but that's what we're trying to convey. You anticipate the defence, it's in the pleadings. It'll be that the rate was varied by an oral agreement. And you know, if you want to know about Hoyts and Spencer, I think it's 23 Commonwealth Law Reports, where it was, ask Professor Bigwood, he's the expert in this area. You're not talking about Hoyts and Spencer at this point. You're saying the only defence is that there's an oral agreement, but the contemporaneous documents, emails, letters, show the parties always proceeded on the basis of an April 17 delivery date. Then you state the issue. Can the defendant prove, contrary to the contemporaneous documents, that there was a binding oral agreement to vary the delivery date. No reference to Hoyts and Spencer, no setting out emails. You might have to do that with emphasis and underlining, but that is framing an issue. I'm guilty of this I'll be guilty of it 3 times tomorrow when I have to give an extemporary judgment. I'll be saying the issue here is whether I'll break all these rules. I'll say this is an application under Section 36 of the Property Law Act. I won't have said who does what to who. I'll get it wrong, get the application before the facts. And I might say the issue here is whether there should be an interlocutory injunction to stop the brickmaking factory belching smoke on the little old lady's house. Now that's great. That is the issue, whether I should grant an interlocutory injunction. But judgments and a lot of your submissions will phrase something at a level of generality. You might say, the issue here is whether the defendants breached the contract. That would be a way in which you would phrase the widget problem. Now that's all well and good, but it's at a level of abstraction that doesn't really let the judge know what the case is about, even in a very preliminary way. If you're for the claimant in a misleading deceptive conduct case, you'd be saying, if you phrase it generally, the issue is whether the claimant's entitled to recover damages for contravention of the Australian consumer law. Again, correct, but too abstract. Adding in fish and chip shop, coffee shop might add a factor or two around it. But the issue is whether the respondent engaged in misleading and deceptive conduct in leading the register to believe that the coffee shop had very good prospects of doing just as well in the future as it had done in the past. That might be something if it's based on the pleadings. I've just chosen here to frame it not as the way a claimant would do, because I want to emphasise upon you that it's not just how the claimant frames the case, it's the counter framing by a respondent that is important. And here I've done what is a deeper framing of the case that you can just read for yourself. 66 words, fact, fact, fact. I don't need to talk about, the law representations as to future matters. Can the respondent be said to have engaged in misleading or deceptive conduct when everything he said was true? Well, what do you think? That, call that a rhetorical question if you want to, but that's issue framing from the respondent's point of view. I'm telling you what to do. I'm not telling you what I do. I break all these rules every day and I'll break them tomorrow with every piece of writing I do. I try to do, at least on the first page or two, a heading called the issue. Ms. Connolly will vouch for that. But I don't usually get the issue in the first paragraph, so not great. But there are 2 problems. The second one is the one that I've already identified, framing the issue in the vague, unparticularised way, a vague general way. The piece of writing that starts off, as it were, once upon a time, the claimant went looking to buy a coffee shop. Blah, 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 blah. On we go. Then we get to the law, and the Australian Consumer Law, Section 18 says this and that. And at about page 7, the issue sort of bubbles to the surface in the course of writing it as a piece of creative writing. Because what you've been doing is writing in the middle. You've been writing the middle. Now you've got to write the middle at some stage, and there's a heck of a lot of work that goes into writing the middle. All the things you've got to tell the judge about, and the middle is a hard slog. It is, though, easier to middle if you've already worked out what the issue is. But too many of us write all in the middle. it's all middle. So that's the problem. That you read this and somewhere there buried without even a heading is the issue that I have to decide. It's nice if you put a heading at page 7 when you eventually get to it, but I really would have preferred that to be on the first page. So I'm not going to tell you how to write these things. A perfectly framed issue on page 1 is the first thing you write. You should have a go at it, I think, because that will, set the structure for the middle. But you might have to come back and write and rewrite the issue framing at the start. You might have to spend a lot of time on writing and rewriting the first couple of paragraphs and junking things from the middle, adding things to the middle, reframing the middle. I don't care how you write it, but having a good beginning is a good beginning. There are books that teach you how to do these things and lots of stuff online as well. If you go through them, people like Garner tell you about how to improve issue framing, try not to mix up too much facts and law, short sentences, just enough detail to tell the story, avoid unnecessary detail, sound objective, brackets, even if you're not, save the argument for later, end with a question mark. And of course, if you're writing submissions that are going to lead to a judgment, they might be fairly general questions, a long time ago, but was there a contract? What were its terms? Were the terms breached? Did the breach cause loss? How much loss? If there's 5 issues, 5 live issues, 5 contested issues, you're going to have an issue framing exercise under each of those general headings. But they're the things that you're working towards. It's not just that there might be one issue in any one case. There may just only be one issue in any one case. Who threw the first punch? Can you be satisfied that he heard the direction? But there might be any number of issues that you have to frame up under each issue. And as I said, counter framing is important. This is just an example which fair use doctrine applies for any intellectual property lawyers from my borrowing this from Professor Garner. In Missouri, a deaf person who is arrested is entitled to a licensed certified interpreter. Joe Pearson, a deaf person, was arrested for driving whilst under the influence. Police retained an unlicensed, uncertified interpreter to talk to Pearson. She interpreted Pearson's words as refusing a breath test. Can this court revoke Pearson's licence based on the uncertified interpretation of an uncertified interpreter? Well, what do you think? I've already dwelled a little on why we don't issue frame. Short answer is we're all too busy. And it's often true to Mark Twain, but it goes back a bit longer. And as my former associates and other former Court of Appeal associates had to read my judgments on appeal, I wish all my judgments, every judgment I've ever written over the last 15 years had been shorter. If it had more time, they would have been shorter. I would have planned them better. I would have handwritten every last word rather than handwriting a fair bit and dictating other stuff. So they would have been shorter. And whether you're a law student doing pro bono work or whatever your situation is, whether you're doing an assignment or you're doing a submission, you take a heck of a lot of time reading the material, doing the legal research. You've got it all there. You kind of got it in your head. You've got it all laid out on the table or on the computer, and you get up the blank screen and you go, okay, I've got this. Let's blast away. We'll do that all the time. Just as an aside, I'm going to Oxford in a couple of weeks. I'm meeting up with a Canadian friend and we did the BCL together. It was really cruel. You had to do these exams at the end of a couple of years. And probably like students here, my objective was to demonstrate in my answers on the exam script that I'd done enough work to pass, to tell Professor Attia or whoever it was paper that I had done a lot of work. I was like a sponge, and I was going to give back to him as much as I could to show that I'd read so many cases and understood stuff. My very good friend who didn't spend a lot of time studying was sitting across the way in my peripheral vision. And even though I'm concentrating on what I'm doing, I couldn't help but notice he was regularly putting his pen down. And I'm thinking, oh God, this guy's Gord's going to crash and burn here. Like hasn't done the work, putting the stuff down. But he was doing a bit of thinking, obviously, and he got a really good mark. I think the teachers here in the room probably like those sort of exam answers. And judges like to read those sorts of submissions, and probably everyone likes to read judgments that are nice and neat and short. So time is the enemy. People think about legal writing. I've concentrated on writing in the beginning, but you've got to see this in context. And we all try to do 4 tasks at the same time. There's the madman, that is, all these mad ideas, or all these mad or possible ideas that you've got from reading the law and reading the material. And we used to have this thing called butcher's paper, but we all had butchers, and when butchers wrapped the meat up in paper, and you could buy it. And some of my friends would have their barrister's chambers butcher's paper on the wall where they're mapping out complex cases. But it's on butcher's paper or whatever, on notepad, you're just writing down, as you know, if you're trying to do a good assignment, you're writing down before you start the thing, all these ideas that you've got. Same with writing submissions. You've got all these ideas and notes. From that madness, you've got all this stuff and you've got to just put it in some order. So that's the sort of doing the architectural plans. And that can require a lot of time, and it's time well invested. Even though we all are short of time, it's a good use of your time, because if you don't do the architectural exercise, you're going to spend a lot more time building and rebuilding. So detailed plans. Then once the plans are done, it's the carpenter following the plans, not concentrating that much on thinking, where do I go next? You're not writing a creative novel that just go with the flow, as many great authors do. They don't even have a plot. They just let it flow. That's not writing submissions. But if you've got a detailed plan that you write to, then you can concentrate on the writing to make the writing better. And then there's the stuff that you have to go back over, which is the judge, but that's what this professor of literature says. That's the judge going back and, oh, that word could be better, needs a comma there, that fine tuning at the end. So we all are inclined to try and do at least the first 3 in one step. Now, I breach all these rules as well, but there are obvious rules that you should use in a piece of legal writing, whether it's just an analytical piece of writing advice to a client, or a piece of persuasive writing, which are what submissions are. And I've got them there, you can read, and I'll draw a breath while you do. I'm happy to have the PowerPoints to the centre. But these seem like obvious rules. But it's worth thinking about them. Don't slab out long quotations of cases. If you have to slab out a couple of paragraphs, highlight the bit that's really important, bracket out, emphasis added. I don't know the facts of every case you're citing. Now, I've alluded to this earlier. Louis Brandeis, one of my many judicial heroes, his name starts with B. There's no such thing as legal writing, only rewriting. Well, that's all well and good for you, Justice Brandeis. You weren't as busy and didn't have as many cases to decide the year as I do. But importantly, I think it's very wasteful of time to have to go back and rewrite stuff that you shouldn't have written in the first place. And you wouldn't have written in the first place if you'd had a plan. That, by the way, isn't a piece of Brandeis's writing. It's the first page out of Orwell's 1984. So you do have to rewrite, improve. But I go through draft after draft after draft, and I don't do it all on the screen because I don't want to go blind, and I like to sit out on my back deck and do the, I was going to say George Orwell, I don't put myself in his category, I get the pen out. But rewriting is essential, but if you don't organise yourself, you're going to spend too much time rewriting. Using headings to your advantage. This is a case involving Oliver, who was sued along with the company over a satirical piece he did about a West Virginian coal company. And you can see there that the headings are effective. I'll just leave it at that. And I'm telling Bob a few things. All of John Oliver's speeches are protected by the First Amendment. You can't sue people for being mean to you, Bob. Like it's almost comic, but that's what you should be if you're acting for a comic, but maybe you should be a bit more serious. But you can see how effective headings can be. I don't think this would go down with many courts in Australia, but you know the point I'm making. Let the headings do some work, frame up the issues in a way that suits your case. If the judge accepts the framing, you win on that point, whether it's the contract, whether it's breached or whatever the issue is. Enforcing the framing. Dealt with this briefly. You've got to but you've got to engage with the other sides. Justice Keane, when he was on the Court of Appeal for a while, had long leaving, went to America, and he was very disappointed at the oral advocacy. He was expecting extraordinary oral advocacy. Now, part of the problem is they only have 20 minutes or 30 minutes, and it's extraordinary, like how good those advocates are. I've been to some superior courts in the US, and they just do amazing things. They have amazing memorandums, and I'm not critical of their advocacy, but in these, New York courts of appeal and higher courts, he felt it was almost like the lawyers there were just doing sound bites and press releases. And of course, you've got to do that, but on that level, you just sort of hopefully preaching to the converted, but you're not probably converting the ones you haven't converted. And a judge might want to fine for the little old lady, but if the judge has got concerns that the brickmaking company might have a legal entitlement or shouldn't be shut down, you've got to engage with the judge's concerns. And don't interpret if a over-talkative judge like me hounds you with questions that judge is against you, because I can often force, distill the other side's submissions, which I've read. And when I'm saying to you, what about this? How can you say? What I'm saying is persuade me. So if it's an angry tribunal member or an angry judge or just an enthusiastic judge hammering you with questions, it doesn't mean you've lost the case. And it doesn't mean you go, oh, I've lost that case. Someone's told me I should jettison the bad arguments. I'll abandon that point. Sometimes you do have to abandon dead points or ones that get in the way of good arguments. But don't interpret the fact that a judge is asking you a question as saying you're going to lose in this point. It's often, at least when I do it, it's saying, you've got this problem, you've got to persuade me. And part of it, of course, is that you should embark on that exercise in your written submissions and in your oral submissions. You don't say, oh, they're misconceived and they're rotters and they're just greedy capitalists and stuff. You know, that's not going to, and don't defame your opponents. It's unprofessional, unproductive. Just, you know, analyze, undermine. That's just common sense apart from being the ethical. And so, I've spilled out the detail, but you know, if you've got 3 good points, lay them out. If you've got 3 good reasons why the other side's contentions lack merit, lay them out sooner rather than later. And it's also not bad to just inject a bit of, judge might have thought the other side's arguments are pretty good. You might say, well, whilst the arguments about misleading conduct by silence, the one about the coffee shop, well, the applicant's argument about misleading conduct by silence may have superficial appeal. It doesn't withstand careful scrutiny for these reasons. Now, what message is sending to the judge? Your little provisional thought was pretty superficial. You're not a superficial person. Change your mind. Oh, I don't care what you think, but there is an element of appealing to and only it's, you know, well, it's plausible, you know, convincing until you start thinking about it. So you're playing with brain, but you're also having to appeal on a deeper level to people who aren't machines. That's worth thinking about. That's a terrific quote about advocacy. I mean, some people must be crazy. Some solicitors brief these barristers who they're just completely hopeless. Oh God, he's a fighter. You know, he fights. He really fights. He fights with all the judges. He loses most of the case, but gee, he puts up a strong fight. Now, maybe you do have to fight with judges. I fought with judges when I was a barrister, and you know, I fought with barristers as a judge, and it's all well intended. Like some judges I used to appear in front of really like to fight. They'd be disappointed if you didn't have a cut and thrust of the oral dialectic. But usually you're not going to get anywhere by arguing with the judge in an aggressive kind of way. And clients, particularly including lay clients who've only seen things on television, might think that, you know, they want someone who, like those American TV dramas, gets there and cuts up every witness and is that kind of lawyer. Well, they might want that, but they probably want to win the case. And you're more likely to win the case if the judge thinks, or a jury thinks, that I can trust this person, they've identified the issue, their submissions are helpful, they haven't misled, exaggerated, misstated, they've acknowledged weaknesses in their case, but gave an argument in response. So that's, I think, the key. And I've really covered off these points already. What judges hope for, well, we hope to have really want assistance. We're time poor. We have limits on how much we can absorb. At the start, at least, we just want to know the essential facts. I don't want to know the date of the contract. I don't want to know how many grams of methamphetamine was seized during the raid. I don't want to know that. If one of my colleagues, or dare I say it, if I'm doing a bail application tomorrow, I don't want, you may have to tell me, we're in the middle, that the defendant's charged with possessing 24.6 grams of pure methamphetamine. That may be important to the seriousness of the case. But I don't want the submission to start. The Queensland Police started an operation called Operation Walsh. And in the course of that operation, the defendant came to their attention, and by filling telephone interception, drone. After research, they found 24.6 kilograms of methamphetamine, blah, 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 blah. Or there's 24.6 grams found in their house, let's say. That's interesting, but I want to know from the applicant why I should grant bail. Because the defendants will be saying it's an unacceptable risk of committing a further offence. That's what I want to know. And so if you've got a client with a bad history, I'd have to say right up front, the applicant's got a serious criminal history for drug offences. But those offences were committed before the defendant had an opportunity to engage in rehabilitation. They've never been granted parole or probation or community service. They now have an opportunity to, if granted bail, to go into a residential rehabilitation facility. Therefore, the risk of committing further offences are reduced to an acceptable level by the imposition of conditions that include random drug tests, residence at the rehab, blah, 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 blah. That's all you need to say in the first paragraph. You can tell me all the stuff later, but that's what I need to know. So whether you're appearing pro bono through the Pro Bono Centre or one of the community legal services, mental health tribunal, or you're appearing in some appeal in the full federal court, here's a tip. Just imagine you're in one of those US courts, I've been in them, where you've got an appellate court in New York, has got 15 cases on its docket that afternoon. They put all these memorandas and they're supposed to have 15 minutes. The judges come in and go, hours. Everyone's got to reduce their time. And okay, how long are you going to be? And Professor Walsh says, I'll be 7 minutes and 2 minutes in rebuttal. And they keep them to those times. Now imagine if you had 7 minutes, as I saw these cases. Imagine you have 7 minutes to present your case and 2 minutes in rebuttal. Fortunately, we don't sort of hold you to those sort of tight time limits here, but that's how they roll in the United States. Just imagine if you had 7 minutes or 9 minutes in total, saying by a contract dated. So just think about that. Just imagine that that's all the time you just say. Well, that's what you should be saying. Those 5 minutes of your oral submissions, that's what you should be saying on the first page of your written submissions. So that's not a bad way to start. Then you write the middle. Then you write the end. And the end can be as boring as just repeating the start, but you've developed the argument, so the end should be a bit different. The closing argument should be a bit different. And of course, oral submissions can't vary from the written submissions unless they're responding to new things that have come up. They can amplify points. But oral submissions shouldn't just be, can I take you on it to page whatever, and we're going to read this together. I mean, it's a burden to have to do this, but there has to be something fresh in the oral submissions. But the closing part is not to be forgotten. I've concentrated obviously tonight on the opening rather than the closing. Now, this is a long way of saying that to do this, to write a good piece of persuasive writing in submissions, to write a good piece of issue framing is really hard. takes a lot of effort, takes a lot of time. And that's the great novelist David Foster Wallace about effortless writing. I mean, it's just so true. I'm sure there's some people who just dash it out and they're just brilliant and they get the Nobel Prizes for literature and so on. And, you know, I've had the privilege to be around barristers and judges who can just do it well without having to ever rewrite very much. But the whole point is writing in order to reduce the effort on the reader. Second favourite B, Lord Bingham. I wrote an obituary in the Borough Journal, Hearsay. This is one of the terrorist cases which issues came up about whether in these tribunals in the UK after 9/11, all the aftermath, that the government could rely upon evidence that had been improperly obtained in foreign countries. That was the issue. And just read that. It is, I think, clear that from its earliest days, the common law of England, pretty good sentence. Later on, he was in dissent on this point. Other members of the and this is his critique of that point of view. That is a test which in the real world can never be satisfied. The foreign torturer does not boast of his trade. The security services secretary has made clear do not wish to imperil their relations with regimes where torture is practiced. The special advocates have no means or resources to investigate. The detainee is in the dark. Short sentence, euphonic. It is inconsistent with the most rudimentary fairness to blindfold a man and then impose a standard which only the sighted could hope to meet. Now, Lord Bingham might have just dashed that off in his cottage in Wales one weekend. He might have just got that right and perfect the first time. But I just think he might have worked on that a bit. It wasn't enough to persuade his colleagues, but I find it strangely persuasive. When I was at Oxford, I was sitting in the law library one night and this big case had recently been decided in the House of Lords about secrets that had been stolen from British Steel Corporation. They were bringing injunctions against Granada House of Lords, and who's to later be Lord Hoffman, but his Hoffman QC at the time was for the big bad British Steel Corporation. And I'm reading the submissions at the start of the judgment, as you do, well, you should do, if they're in the reports. And, you know, the Granada Television painted this as a free speech case and away we go. And he just counterframed it. This isn't the case about freedom of speech. Read on. Don't look over there. They haven't raised this as a free speech case. The issue is simple. And look how it's done just perfectly. Now, it probably breaches Garner's rules by having subparagraphs and it's too long or something. But I can remember sitting there and I just said, this is brilliant. I might have said a 4-letter word before it is brilliant, but I just thought this is really good advocacy. Who is this guy? The rules that I've been explaining, I think, apply generally. Of course, some courts have templates and you've got to follow practice directions. High Court on special leave applications, you've got to state what the special leave issue is. Now, that's a discipline that the High Court imposes because they're only going to grant special leave if there's an issue requiring special leave. So they want on the first page of the submission, what is the issue in respect to which special leave is to be granted? Now, they make you do that, but you should But every judge at every level is a type of rationality. Some have two brains, some have a brain, some have almost a brain. So it's just difficult at any level to overcome the fact that judges are pressured, sometimes very tired, suffering from mental health issues and the like. And I must say that I feel, really tired after I've done a day of applications. I may have decided 10 cases. One of my colleagues who'll decide 6 bail cases tomorrow will feel really tired at the end of that, having maybe been able to do a little bit of preparation on the material that's already on the file, with submissions just coming in the last minute. But when I go to Toowoomba or somewhere and I sit in the same courthouse as the magistrates, I see magistrates on domestic violence days, and they used to do 50 in the morning up at Toowoomba. One magistrate doing 50 cases. I was up there recently and said, "Oh, how's that going?" And they said, "Oh, well, it's got better and it's got worse. We've now got 80 cases, so we do 40 one day and 40 another." Talk about bounded rationality. How much time have you got to decide those, and what cognitive shortcuts? And it's just all too hard and they all blur together. And so the people at the lower end of the judicial pyramid, high volume QCAT tribunals, deciding cases about residential tenancies, mental health tribunals, they've got it hard. We've all got it hard, but let's face facts, they've got it really hard. I can take the work home on the weekends like some of us do, but they have very, very difficult mornings every morning. So that applies everywhere. But whatever the court is, what's the case about? What's the issue? What's the answer? We want to know that pretty early on. A good way of doing the same thing that I mentioned earlier is if you're going off to do a case in the mental health tribunal or the magistrates court or the Court of Appeal pro bono, and you bumped into your neighbour or your housemate says, "What case you're going to do today?" You simple explanation. You wouldn't say, "Well, pursuant to section 236, you just wouldn't say that. You'd say, well, you'd say who did what to who, why they're in court, they've been charged or they're suing for damages, trying to get an injunction, whatever. The issue is, boom. Now, if you're going to say that to your next door neighbour as you're walking to the bus, that's more or less what you should say to the busy magistrate. Let's just take a common or garden assault case in the magistrate's court. X in the head. I'm making for the defendant, by the way. We're not going to die punch in the head. The defendant says he acted in self-defense because first. X was drunk, witnesses, bracket also having been in the pub, with different powers of observations and different cognitive impairments and different degrees of sobriety. Witnesses called by the prosecution gave inconsistent and unreliable accounts of events. Given the unsatisfactory and confused state of the prosecution evidence, can the court be certified beyond reasonable doubt that the defendant threw the first punch? So it's a fact-specific issue. Who threw the first punch? It's not a generally framed thing. Has the prosecution excluded a defence of self-defence? Interesting, that's the issue. But that doesn't have any facts in it. So you've got to embed the factual issue in the issue that you frame. And that last sentence does it also by loading in, obviously, as I inexpertly did as a 19-year-old, that in the criminal courts, can you be satisfied beyond reasonable doubt? So that's just the simplest of examples. As I've explained in the last few minutes, really the hardest cases to win are in time-poor lower courts and tribunals that have dozens of cases in the pocket. These are the places which the poor the underrepresented, the unrepresented, the marginalised, disadvantaged appear, and they make very significant decisions affecting people's liberty and welfare. And they're the people who need you and persuade the court to decide the issue in your client's favour. There's one thing you'll remember tonight, I hope, is that judges are human, despite some contrary scientific evidence. We are human. So don't overburden us with unnecessary facts, too much information the first few minutes. At the facts and frame the issue in a way that the judge accepts the case is half won. That's the point. Bring things a little closer to home, although this is from America. You'll see there an article. It's actually back in 2007 from New York University magazine. It's about this old guy called Anthony Amsterdam, who did decades of pro bono work for people on death row in the United States as a very young lawyer. And you'll see him as a young lawyer, indeed Young Man of the Year, so declared the Philadelphia Junior Chamber of Commerce in 1966. As a young man, a very young lawyer, he appeared in the US Supreme Court in 1967. His use of language is described as so perfect and so powerful and so utterly logical, he could take a pile of coal dust and make a diamond out of it. He delivered in that case called Furman, in which the US Supreme Court went on to abolish the death penalty, at least for a while. And he swayed the key swing judge at the time, Justice White, who described Amsterdam's oral argument as possibly the best he'd ever heard. And he did this all as a young person. We do our best work when we're young, I must say. Apart from appearing in cases, Amsterdam would edit other people's work, these death row petitions, of which there are sadly so many in the United States. And it said that he had the care of a poet for every word. He explained someone sent him something and he changed it and they changed it back and he sent it back and he changed it back. And he said the point and the way it was expressed, I'll just read this. I want the justice to stop right there and think about it. The point of the way it was expressed proves to be a winning point. All this involved effort, although the effort may not have been apparent to the reader. And he taught clinical legal education at law schools. Now, I mentioned him because I didn't need to mention Ruth Bader Ginsburg. You've all seen the documentary and the audio of her in the RBG documentary, which is standing up in the US Supreme Court and saying the issue for today is, and of course, so powerful. But she's not the only person who has done powerful advocacy. Fortunately, we abolished capital punishment in the state 100 years ago, so we don't have that barbarism. And I'll just mention this, that one of the other people I'm going to see, I hope in a couple of weeks in Oxford, is another guy who did the BCL. He's a Republican voting, Ronald Reagan supporting guy, really good friend of mine. Conservative guy. If you've seen Ned Flanders in The Simpsons, looks very much like Ned Flanders. And from a big law firm in the Midwest and went back to this big law firm and did all this Eurobond financing of that. But his firm, pro bono work, and they were acting for people on death row. And I've never seen this guy who's like Ned Flanders so viscerally agitated as when he talked about the barbarism. Now, I don't know whether his firm saved many people on death row. They may not have saved anyone, but I would hazard a guess that his work and the work of the firm in doing those sorts of pro bono cases was far more meaningful to him, and he made him feel more like a lawyer than all the other work that he did in his career put together. Thank you.